Chapter 13. A contract is binding. This agreement must be made between parties who have the capacity to do so. They must also truly agree so that all parties have really consented to the contract. This chapter explores elements of contractual capacity of the parties and the genuineness of their assent. Okay, what's the difference between status and capacity and factual capacity? Anybody? Yes? Some persons lack contractual capacity, a lack that embraces both those who have a status and capacity, such as minors, and those who have a factual capacity, such as persons who are insane. What's the black letter definition on page 248, 13-1A, contractual capacity? Anybody? Right from the book.
Is the ability to understand that a contract is being made and to understand its general meaning.
Thank you. However, the fact that a person does not understand the full legal meaning of a contract does not mean that the contractual capacity is lacking. So contractual capacity is what? Thank you for reading that. All of you. Is the ability to understand that a contract is being made and understand its general meaning. However, the fact that the person does not understand the full legal meaning of a contract does not what? Mean that contractual capacity is lacking? What's that mean? Everyone's presumed to what? Have capacity unless it's proven that capacity is lacking or there is status capacity. What happened to Jacqueline? Benjamin? Jacqueline, age 22, entered into a contract with Sunrise Storage Company, but later claimed that it was not binding because she what? Did not understand several clauses in the printed contract. What's going to be the answer to that, Jesus? Is that a binding contract? Mr. Spencer, is it?
What?
Is it a binding contract?
No.
With Jacqueline?
Yes.
How old is she?
Above 18.
Therefore, it's what?
Binding.
You got it, sir. It's binding, right? Jacqueline, age 22, entered into a contract with Sunrise Storage Company, but later claimed that it was not binding because she did not understand the several clauses in this printed contract. The contract was binding. No evidence supported her claim that she lacked capacity to contract or to understand the subject. Contract capacity can exist even though a party does not understand every provision of the contract. What is status and capacity, my beautiful people, hardworking people? Over the centuries, the laws declare that some classes of persons lack contractual capacity. That the purpose is to protect these classes by giving them the power to get out of unwise contracts. Of these classes, the most important today is the class identified as minors. Until recent times, some of that class were held to lack contractual capacity in order to discriminate against them. Yeah, people of color too, right? Mm-hmm. Examples are married women and aliens. Still other classes, such as persons convicted of and sentenced for a felony, were held to lack contractual capacity in order to punish them. Today, these discriminatory and punitive capacities have largely disappeared. Married women have the same contractual capacity as unmarried persons by virtue of international treaties. Discrimination against these aliens have been removed. Did I give this case to anybody? We really mean equal rights? Petty versus Montgomery? I don't think so. Not. You know what your presentations are, right? Okay. An Alabama statute provided that a married woman could not sell her land without the consent of her husband. What? A married woman can't sell land because without consent of her husband? Andrew? That's what he said? Montgomery made a contract to sell land she owned to Petty. Montgomery's husband did not consent to the sale. Her husband said no? What? Montgomery did not perform this contract and Petty sued her. What's the defense? The defense was raised that the contract was void and could not be enforced because of the statute. What did Petty say about that, Mr. Rivera? Petty said the contract was what? Ms. Smith? Unconstitutional. So the question is it constitutional to stop a married woman from selling property without the consent of her husband? To say yeah or no? Answer? Oh, this is a case that is Alabama, and this is one of the rare cases where the book has it wrong. It's 345 SO2D. It's 631 in Alabama in 1977. Yeah, that's one reason I didn't give this one out, because I know this one is one of the ones where citations was off. The statute was unconstitutional. Constitutions, both federal and state, guarantee all persons the equal protection of law. Married women are denied this equal protection when they are treated differently than married men and unmarried women. The fact that such an unequal treatment had once been regarded as proper does not justify its modern continuation. Oh, they changed it? Okay. Let's go to page 249. Factual capacity. Want to read that for me, please, Mr. Andrew? Factual capacity.
Factual capacity contrasts with incapacity imposed because of the class or group to which a person belongs. A factual incapacity may exist when, because of a mental condition caused by medication, drugs, alcohol, illness, or age, a person does not understand that a contract is being made or understand its general nature. However, mere mental weakness does not incapacitate a person from contracting. It is sufficient if the individual has enough mental capacity to understand, to a reasonable extent, the nature and effect of what he is doing.
Okay, thank you. So here they're saying what? Here it contrasts to the incapacity imposed because of the class, right? Mental condition, right? That's going on. Thank you for reading that. 13-1B. When does a person reach majority?
18,
At common law, when?
21.
At common law, when?
The day before the 21st.
Thank you. That might be on a test someday, right? Exactly, right? So minors may make contracts, protect them. However, the law has always treated minors as a class lacking contractual capacity. At common law, who's a minor? Any person, male or female, under 21 years of age was a minor. At common law, minority ended the day before the 21st birthday. The day before the birthday rule is still followed, but the age of majority has been reduced from 21 years to what? 18. Why? I gave you the answer earlier. Why? Because of the Vietnam War, right? Please turn to the back of the Constitution, back to Appendix 2, Constitution of the United States of America, and Amendment number 26, passed by Congress March 23rd, 1971, ratified July 5th, 1971, Section 1, the right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of what? Age. If you could die in the Vietnam War without voting for the president, and die in the Korean War, and die in World War I, and die in World War II, and die in World War I, and die in the Spanish-American War, and die in whatever other wars it might be because you couldn't vote for the President of the United States of America, they said, what? We're changing that. During the 60s, right? We're changing that. That if you can go to war and die, then you can vote for the President of the United States of America who ships you off to go off the war. That's why you can vote at 18. And it's only been since what? 1971, okay? So all those men who went off to fight, in Vietnam and in Korea and World War II and World War I, got drafted, other things like that, they couldn't vote for the president, right? Unless they were 21. So all those 18-year-olds, 17-year-olds, okay? So that's why. And then, what do we have? Women, passed by Congress June 5th, 1919, ratified August 26, 1920, the 19th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power by appropriate legislation to enforce the provision of this article. And when did black women in the South get the right to vote? August 6, what? 1965. This one was passed in 1920. Black women in the South had the right to vote when? August 6, 1965. And what about black men? When did they get the right to vote? Passed by Congress, this is all on AA-12, appendix number 2. Passed by Congress February 27, 1869. Ratified March 30th, 1870. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. And we know what happened to that, right? They kind of ignored that, right? They not kind of, they did. And that's why you needed what? It's rights bill of what? 1965, August 6, 1965. What year is this? 1869. What year did it get passed for the South? August 6, 1965. That, my beautiful people, is history, right? Okay, now, what else I normally say about this? Minor power to avoid contracts with exceptions that will be noted later. Contract made by minor is voidable at the election of minor. Remember we talked about Michael Jackson makes a contract with Motown. He's 10 years old and everything like that. He can get out of it if he wants to. Or he can do what? What else can he do later on in life? He can do what? He can, begins with an R. Ratify, right? You all read this chapter, ratify, right? What constitutes avoidance? A minor may avoid or disaffirm a contract by expression of an intention to repudiate contract. Any act inconsistent with the continuing validity of the contract is also an avoidance. Time for avoidance. A minor can disaffirm a contract only during minority and for a reasonable time after attaining what? There it goes, majority. So as long as you're what? A minor, you can disaffirm it, but once you become 18, what happens? you're ratifying. After the lapse of reasonable time, the contract is deemed ratified and cannot be avoided by the minor, right? So Michael has to do, becomes 18 years old, right? Determine what he's going to do. Minor's misrepresentation of age. What happens when they lie about the age? What then? Generally, the fact that the minor has misrepresented his or her age does not affect the minor's power to disaffirm the contract. Some states hold that such fraud of a minor bars contract avoidance. Some states permit the minor to disaffirm the contract in such a case, but require the minor to pay for any damage to the property received on the contract. In any case, the other party of the contract may disaffirm it because of the minor's fraud. Turn to page, we're on page 250. CPA examination. Restitution by minor after avoidance. When a minor disaffirms a contract, the question arises as to what the minor must return to the other contracting party. Original consideration intact. When a minor still has what was received from the other party, the minor, on avoiding the contract, must return it to the other party or offer to do so. This is, the minor must put things back to original position or, as is called, restore the status quo ante. Original consideration destroyed or damaged or destroyed. What happens if the minor cannot return what has been received because it has been spent, used, damaged, or destroyed? The minor's right to disaffirm the contract is not affected. The minor can still disaffirm the contract and is required to return only what remains. The fact that nothing remains or that what remains is damaged does not bar the right to disaffirm the contract. In states that follow the common law rule, minors must thus refuse to pay for what has been received under the contract or can get back what has been paid or given even though they do not have anything to return or return property in damaged condition. There is, however, a trend to limit this rule. What about recovery of property by minor on avoidance? When a minor disaffirms a contract, the other contracting party must return the money. Any property received from the minor must also be returned. If the property has been sold to a third person who did not know the original seller's minority, the minor cannot get the property back. In such cases, however, the minor is entitled to recover what? Property's what? Monetary value, right? Money, or the money received by the other contracting party. What are necessaries? Who has the case of Smith versus Prince George Hospital?
I was gonna say logic.
Oh, you do. Did I have you do it already?
Yeah, you did.
Okay, very good. That's right. We did do it. That's why I'm going over this now. Thank you. So everyone should know the answers already, right? In case it shows up on testimony day, right? What constitutes necessaries? Ordinary necessaries were limited to those things absolutely necessary for subsistence and the shelter of the minor. Thus limited, the terms would extend only to food, clothing, and lodging. In the course of time, the rule was relaxed to extend generally to things relating to the health, education, and comfort of the minor. Thus, the rental of a house used by a married minor is necessary. What about the guardians and parents? What about their liability? Jesus. Mr. Thomas.
When a third person supplies a parent or guardian to the minor with goods or services that the minor needs, the minor is not liable for these necessaries because the third person's contract is with the parent or guardian, not with the minor.
Thank you. When necessary medical care is provided minor, a parent is liable at common law for the medical expenses provided to minor child. However, at common law, the child can be held contractually liable for the necessary medical expenses when the parent is unable or unwilling to pay. We've seen the case already, the Smith case. Ratification of former minor's avoidable contract. A former minor cannot disaffirm a contract that has been ratified after reaching what? Majority. What constitutes ratification? Consists of what? Any words, conduct, or the former minor manifesting intent to be bound by the terms of contract made while minor. Formal ratification, generally no physical form is required for the ratification of minor's avoidable contract, though some states written ratification of declaration of intention is required. What about the time for ratification? A person can disaffirm a contract any time during what? Minority, and then what? A reasonable time after that, but of necessary can ratify a contract only after attaining what?
Majority.
Minor must have attained majority, or the ratification would itself be regarded as what? Voidable. Contracts that minors cannot avoid. What are they? You can't avoid educational loan. And by the way, you can't get out of it in bankruptcy either, right? This was talking about that in my Business Law 2 class, or on that bankruptcy chapter, you know. Statutes in many states deprive a minor of the right to avoid an educational loan, a contract for medical care, contract while running a business, a contract approved by a court, contract made in performance of legal duty, a contract dealing with a bank accounts, insurance policy, or corporate stock. Turn the page. Liability of third person to minor's contract. The question arises as to whether parents are bound by the contract of their minors. The question of whether a person consigning a minor's contract is bound if the contract is avoided by also arises. Parent, liability of parent. Ordinarily, a parent is not liable on a contract made by a minor child. The parent may be liable, however, if the child is acting as an agent of the parent, okay, and making the contract, okay? A parent is liable to the seller for the reasonable value of necessities supplied by the seller to the child if the parent had deserted the child. Liability of consigner. When the minor makes a contract, another person, as a parent or a friend, may sign along with the minor to make the contract more acceptable to the third person. With respect to the other contracting party, the consigner is bound independently and of the minor. In other words, they have to pay. That's what that means. Consequently, if the minor affirms the contract, the consigner remains bound by it. When the debt to the creditor is actually paid, the obligation of the consigner is discharged. If the minor affirms the sales contract but does not return the goods, the consigner remains liable for the purchase price. Mentally incompetent people. 13-1C. A person with a mental disorder may be so disabled as to lack capacity to make a contract. A guardian seeking to rescind a contract made by an incompetent person must demonstrate that at the time the agreement was executed, he or she was suffering from mental illness or defect, which rendered the party incapable of comprehending the nature of the transaction. A Wisconsin jury concluded that Raymond Jones was mentally incompetent when he signed the contract to sell 2 parcels of land to Brian Pizzone at substantially below the appraisal and list prices. The appeals court upheld the trial court's determination that a person seeking to set aside commands because of lack of capacity must prove lack of competence by a preponderance of the evidence. What's the effect of incompetency? An incompetent person may ordinarily void a contract in the same manner as a minor. Upon removal of disability, that is, upon becoming competent, the formerly incompetent person can either what? Or, go ahead, just refer to the contract. Mentally incompetent person or state is liable for the reasonable value of the necessities furnished to that individual. A current trend in the law is what? Treat the incompetent person's contract as what? Binding when in terms the surrounding circumstances are reasonable and the person is unable to what? Restore the other contract party status quo ante. Now, appointment of guardian. What's that all about? If a court appoints a guardian for the incompetent person, a contract made by that person before the appointment if a court appoints a guardian for the incompetent person, what happens to that contract? A contract made by that person before the appointment may be ratified, or in some instances, what? Set aside by the guardian, disaffirmed by the guardian, right? If the incompetent person makes a contract after the guardian has been approved, the contract is what? Void, not merely voidable. So after they've been approved, it's voidable. After they've been approved, it's void altogether, right? So the incompetent person makes a contract after they have a guardian over them, right? It's going to be void altogether. But if they made the contract before the guardian was appointed, then it might be void or voidable. You have to see. All right. What do you do about intoxication? Intoxication. The person wakes up and they don't know who's next to them. Okay? And the night before, they were a little intoxicated, and they went to the Chapel of Love in, I guess, Nevada, right? And when they said, I do, they meant to say, I do want another beverage, right? That's what they thought. But they were for a preacher who was saying, say I do. Are they married? How do you say, yeah, they're married? How do you say, no, they're not married? Who's not sure? Who didn't vote? So, they're at the Chapel of Love. She's drunk. He's drunk. and they say, I do. But they're saying, I do want another Coca-Cola. But instead, they said, I do to married person. They wake up the next morning, who's this person? Are they married? Huh? Yeah, what's that, Mr.?
They're not, just like, one person was like lacking contractual capacity.
Okay. What are you going to say, Mr.?
I was gonna say that in the book it says somewhere, as long as they know that there's they can understand that there's a contract at play, that it's still.
Yeah, I do want another Coca-Cola. Right? The capacity, thank you. The capacity of party to contract, the validity of contract are not affected by the party being impaired by alcohol at the time of making the contract, so long as the party knew that a contract was being made. As long as they knew that they were getting married, right? By the way, who gets married and then gets divorced within a few hours? Who does that kind of stuff? Or a few days? Who does that? Who does that? Huh? Who does that?
Unsatisfied person.
Sure, it's happening.
Who?
Gold diggers?
Gold diggers?
Yeah.
Give me some examples.
So, well, I mean, if a man has a lot of money and then the woman marries him for a few days and divorces him and then takes all his money, they don't want to do it for the money. No, I'm not. Yeah.
Immigrants?
Who does that? Who did that? How many examples of people got married for 12 hours?
Nicolas Cage.
Okay, I've got that written down in my book, yeah. Who else?
There's certain marriages.
Was that Dennis? Does Dennis Rodman do that too? Was Brittany married to somebody for a little while? Somebody Google that. Somebody take a Google.
There's certain
Google.
like marriages that only last for a while.
I'm talking about a few hours. Someone Google. Did you Google it for me? How many hours? How many hours? What's that?
I was reading something. Someone actually got divorced before like the husband was gonna die, because if he died, then she would have all the medical debt. It's kind of like the opposite.
What?
Hours.
Okay, wait. Mr. Rivera has it too. What's that?
Britney Spears was married for 55 hours.
Brittany was married for 55 hours? 55 hours? Not days, but hours? That happens? Huh?
In Vegas.
In Vegas. Yeah, that's one I have written down here also. So, it can happen, right? Notice what it says here. If the degree of intoxication is such that a person does not know that a contract is being made, the contract is voidable by that person. Thank you for finding that information out for me. On becoming sober, the individual may avoid or rescind the contract. You mean you can keep the person if you want to? Or not? On becoming sober? However, unreasonable delay in taking steps to set aside a known contract entered into while intoxicated may bar the intoxicated person from asserting this right. Excessive intoxication is a viable defense to contracts arising between casinos and their patrons. Thus, when a casino comes to court to enforce a market debt against a patron seeks to enforce a contractual debt, and the patron decides to raise a common law defense that a capacity contract was impaired by voluntary intoxication. The courts treat impairment caused by the use of drugs the same as impairment caused by the excessive use of alcohol. What's a mistake? You know a mistake? You know a mistake? That is, a mistake by only one of the parties as to a fact does not affect the contract when the mistake is unknown to the other contracted party. When a contract is made on the basis of a quoted price, validity of the contract is not affected by the fact that the party, for instance, in quotation, made a mathematical mistake in treating the price. If there was no reason for the other party to recognize that there had been a mistake, the party making the mistake may void the contract if the other contracted party knew or should have known about the mistake. Mutual mistake. When both parties enter a contract under mutual mistaken understanding, consider a basic assumption of the fact or law on which the contract is made, the contract is voidable by adversely affect the party if the mistake has a material effect on the agreed exchange, on page 254. A contract based upon mutual mistake and judgment. What happened with the Preakness? I asked you that last time. Huh? A contract based on a mutual mistake and judgment is not voidable by the adversely affected party. If both parties believe that a colt is not fast enough to develop into a competitive racehorse and effect a sale accordingly, when the animal later develops into the winner of Preakness, now add on the Belmont Stakes and the, what's the one in Kentucky? Kentucky Derby, right? As a 3-year-old, the seller what? Cannot what? Yeah, based upon what? cannot rescind the contract based on mutual mistake because the mutual mistake was a mistake in what? Judgment, not fact, right? And contracts when two parties to a contract believe a cow to be barren at the time they contract for sale, but before delivery of the animal to the buyer, it discovered that the assumption was mistaken, such as a mutual mistake of fact, making the contract what? Void. You can get out of it, right? What's it mean to reform a contract? Does it mean to change the contract? No. Reform means what? May petition the court to reform the contract to reflect the actual agreement of what? The parties, right? What's the assumption? One party may have been misled by a fraudulent statement. Such situations, there is no true or genuine assent to the contract, is void at the innocent party's option. What's fraud? It's a generic term, embracing all the multifarious means that human ingenuity can devise and that are restored to by one individual to get advantage over another. It's classified in the law as a tort. However, where a party is induced into making a contract by material misrepresentation of fact, the form of fraudulent activity adversely affects the genuineness of what? Of the assent of the innocent party, and the type of fraud is the focus of our discussion in the chapters on contracts. What's the black letter definition of the word fraud? Page 256.
Fraud is the making of a material misrepresentation or false statement of fact.
With one, thank you, knowledge of falsity or reckless indifference to the truth. 2, the intent that the listener rely on it. 3, the result the listener does or so rely. And 4, the consequence of the listener is harm. To prove fraud, there must be what? Material what? All good question for a test. Material misrepresentation of fact. That misrepresentation is one that is likely to induce a reasonable person to assent to the contract. Statement of opinion. I say to Mr. Patel, Al, I got a sweater for you. It's wonderful. It's great. It's a great sweater. It'll be fantastic. All right? And he buys the sweater. Later on, he doesn't like the sweater. What do you call that? Opinion. Right? Ordinary matters of opinion of value or opinions about future events are not regarded as fraudulent. Forecasts about future state of financial or real estate market must be regarded not as fact, but as prediction or speculation. Statement of opinion may be fraudulent when the speaker knows the past and present facts that make the opinion false. Now, if I say to Mr. Patel, I've got a sweater that's 100% wool, and it's not. What's that?
Material misrepresentation.
Yes, okay, fraud, right? It's not opinion. Justifiable reliance on statement. A fraudulent statement made by one person has no importance unless the other party, what? Relies on the truth of the statement. Check this example out on page 257. Might be on a test someday. Maybe not. After making thorough tests of Nigel Company's pump, Allstate Service Company ordered 100 pumps. It later sued Nigel on the ground that the advertising statement made about the pumps were false. Allstate Service could not impose fraud liability on Nigel for the advertisement. How come? Even if they were false, how come? Because it had not relied on them in making the purchase, but had acted on the basis of its own tests. Disclaimer of reliance clauses are common in commerce these days. Trust and honesty of a salesperson or their disarming statements an individual may normally or obviously agree in sales agreement containing a disclaimer or reliance clause that had no representation have been made to him or her, while at the same time believing and relying upon a representation which in fact has been made and in fact are false, but for which the individual would not have made the agreement. Ordinary purchasers cannot assert justified reliance on statements made by sellers that directly contradict clear and specific terms of their written contract. For an individual, proof of harm for an individual to recover damage for fraud, proof of harm to the individual is required. Injured party may recover their actual losses suffered as a result of fraud, as well as the punitive damage when the fraud is gross or oppressive. Injured party has the right to have the court order the rescission or cancellation of the contract that has been induced by fraud. Turn to page 258. Negligent misrepresentation. While fraud requires critical elements of what? Of a known reckless and made falsity, a claim of negligent misrepresentation contains similar elements except what? Predicated on negligently made false statement. That is, the speaker failed to exercise due care regarding material information communicated to the listener but did not intend to deceive. When the negligent misrepresentation of material fact that the listener relies on the results in harm to the listener, the contract is avoidable at the option of the injured party. If fraud is proven as opposite to misrepresentation, as opposed to misrepresentation, recovery of proven damages, which is punishment damages, right? In addition to actual damages can occur. Because it may be difficult to prove the intentional falsity required for fraud, it is common for a lawsuit to allege both a claim of fraud and a claim of negligent misrepresentation. What's non-disclosure? Under certain circumstances, non-disclosure serves to make a contract, what, voidable? especially when the non-disclosure consists of active concealment. Active concealment, what's that mean? What happened with Fox? Ordinary party to a contract has no duty to volunteer information to the other party. What? Ordinary party to a contract has no duty to volunteer information to the other party? If Fox does not ask her hand any questions, her hand is not under any duty to make a full statement of material facts. Consequently, the non-disclosure of information that is not asked for does not impose fraud liability or impair the validity of the contract. What are the exceptions? Are one of people?
Unknown defect.
Unknown defect, right? A duty may exist in some states for a seller who knows of a serious defect or condition to disclose that information to the other party where the defect or condition is unknown to the other person and is of such a nature that it is unlikely that the other person would discover it. However, a defendant who had no knowledge of the defect cannot be held liable for failure to disclose. What's the other one? Confidential what?
Relation.
If parties stand in a confidential relationship, failure to disclose information may be regarded as fraudulent. In an attorney-client relationship, the attorney has a duty to reveal anything that is material to the client's interest when dealing with the client. Attorney-client has the same legal consequences as knowingly made false statement that there was no material fact to be told the client. A doctor, attorney, they have to tell you exactly what's going on. What's active concealment? What happened with Nigel? Another great question for a test. Active concealment. Non-disclosure more than the passive failure to volunteer information. It may consist of a positive act of hiding information from the other party by physical concealment, or it may consist of knowingly recklessly furnishing the wrong information. Such conduct constitutes what? Fraud. So, you come in to buy the house, right? Not like that. There's a open hole right there in the wall, and there are termites, right? You can see that. However, if someone puts a dresser next to it, you can't see the hole. What is that?
Active concealment.
Active concealment. And that's the example they give, right? When Nigel wanted to sell his house, he covered the wooden cellar beams with plywood to hide extensive termite damage. He sold the house to Canoe, who sued Nigel for damages on later discovering the termite damage. Nigel claimed he had no duty to volunteer information about the termites. Did he have a duty? But by covering the damage with plywood, he committed what? Active fraud, as if he had what? Made a false statement that there were what? No termites. Pressure. What appears to be an agreement may not, in fact, be voluntary because one of the parties entered into it as a result of undue influence or physical or economic duress. What's undue influence? What's undue influence? Are one of people? What is that? Huh? On page 260. What's pressure? What appears to be an agreement may not, in fact, be voluntary because one of the parties entering the contract as a result of undue influence or physical or economic distress. 13-4A. I'm sorry, I didn't mean to cut you off. CPA. An aged parent may entrust all the business affairs to a trusted child. A disabled person may rely on a nurse. Client may follow implicitly whatever attorney recommends. Relationship may be such that, for practical purposes, one person is helpless in the hands of the other. When such a confidential relationship exists, it is apparent that the parent, the disabled person, or the client is not exercising free will in making the contract, possessed by the child, nurse, attorney, but is merely following the will of the other person. Because of the great possibility of unfair advantage, the law presumes that the dominating person exerts what? Undue what?
Influence.
Undue influence on the other person whenever the dominating person obtains any benefit from the contract made with the dominated person. The contract then is what? Voidable. It may be set aside by the dominating person unless the dominating person can prove that at the time the contract was made, no unfair advantage had taken place. The class of confidential relationships is not well defined. Its ordinary includes the relationship of parent and child, guardian and ward, physician and patient, and attorney and client, and any other relationship of trust and confidence in which one party exercises a control or influence over another. When undue influence exists, is a difficult question for the courts, ordinary juries to determine. The law does not regard every influence as undue. An essential element of undue influence is that the person making the contract does not exercise free will. Absolutely recognized type of confidential relationship, such as that between parent and child, courts are likely to take the attitude that the person who claims to have been dominated was being persuaded, and there was therefore no undue influence. Okay, dad marries a second wife. Is he going to listen to her more than us, or us? What do you think? Why? We're his kids. For his kids. He should listen to us, right? Why is he going to listen to the second wife more than his kids that he raised? That doesn't really happen, does it? Yeah, it does. Huh? Just on TV, right? Right? I mean, what can she do that we can't do? Okay, so let me move on. Duress. A party may enter into a contract to avoid a threatened danger. The danger threatened may be a physical harm to a person or property called physical what? Duress. Or it may be a threat of what? Financial loss called what? Economic. Okay. What's physical duress? A person makes a contract on physical duress when there is a such violence or threat of violence that the person is deprived of all free will and makes the contract to avoid harm. Listen, we're a nation of laws, all right? And there's no room for violence in our nation, period. Especially during election time, all right? Especially during election time, all right? People who have the who are eligible voters and have the right to vote should be able to vote unencumbered. And whoever they want to vote for, they should vote for, period. That's all private. All private. So here, duress makes a person makes a contract on duress when there's such violence or threat of violence that the person is deprived of free will and makes a contract to avoid harm. The threatened harm may be directed either at a near relative of the contracted party or against the contracted party. If a contract is made under duress, the resulting agreement is voidable at the victim's election. Agreements made to bring an end to mass disorder or violence are ordinary not binding contracts because they were obtained by what? Duress. One may not void a contract on grounds of duress, merely because it was entered into with great reluctance. It proves to be disadvantageous to the individual. So if it's just a bad contract, right? What's economic duress? Economic duress is a condition in which one is induced by a wrongful act or threat of another to make a contract under circumstances that deprives one of the exercise of his own free will. Wow. Richard Case, an importer of parts used to manufacture highly qualified mountain bicycles, had a contractual duty to supply the manufacturing company needs for specially manufactured stainless steel brakes for 2021 season. Bill Reed was a constant contract with Chase about the delay in delivery of parts, averaging consequences it was having relationship with its retailers, near the absolute deadline for the meeting order for 2021 season. Chase called Reed and said, "I've got the parts in, but I'm not sure I'll be able to send them to you because I'm working on next year's contract and you haven't signed yours yet." What? He's working on next year's contract and he hasn't signed his yet? What's the problem with that statement? Huh?
He didn't sign this contract.
Next year's contract. We're still doing this year's contract. But he says, look, I got a problem with you because you haven't signed next year's contract. I got the parts in, but I'm not sure I'll be able to send them to you because I'm working on next year's contract and you haven't signed yours yet.
That's economic duress.
Yeah, because he doesn't have to what? Sign for next year, right? Chase's 2022 contract increased the cost of parts by 38%. Reed signed the contract to obtain the delivery, but later found a new supplier and gave notice to Chase of his action. The offense of economic duress would apply in the breach of contract suit because Chase case on the 2022 contract because Case implicitly threatened to commit the wrongful act of not delivering parts due under the prior contract, and the company had no means available to obtain parts elsewhere to prevent the economic loss that would occur if it did not receive those parts. Wow. Need somebody volunteer for me on page 262 and read the summary, please? An agreement that otherwise appears to be a contract may not be binding because one of the parties lacks contractual capacity. In such a case, the contract is ordinarily voidable at the election of the party who lacks contractual capacity. In some cases, the contract is void. Ordinarily, contractual incapacity is the inability for mental or physical reasons to understand the contract is being made and understand its general terms and nature. This is typically the case when it's claimed that incapacity exists because of insanity, intoxication, or drug use. The incapacity of minors arises because society discriminates in favor of what? Of that class to protect them from what? Unwise contract. The age majority is what? 18, minors can disaffirm most contracts. If minor received anything from the other party, the minor on avoiding the contract must return what had been received from the other party if the minor still has it. When a minor disaffirms a contract for necessary, the minor must pay the reasonable value of any benefit received. Somebody read the next part for me, please. Minors only are liable for their contracts. Sorry, guys, take a summary.
Parents of a minor are not liable on the minor's contracts merely because they are the parents. Frequently, an adult enters into the contract as a co-party of the minor and is liable without regard to whether the minor has avoided the contract. The contract of an insane person is avoidable to much the same extent as the contract of a minor. An important distinction is that if a guardian has been appointed for the insane person, a contract may be made by the insane person is void, not merely avoidable. An intoxicated person lacks contractual capacity if the intoxication is such that the person does not understand that a contract is being made. The consent of a party to an agreement is not genuine or voluntary in certain cases of mistake, deception, or pressure. When this occurs, what appears to be a contract can be avoided by the victim of such circumstances or conduct. As to mistake, it is necessary to distinguish between unilateral mistakes that are unknown to the other contracting party and those that are known. Mistakes that are unknown to the other party usually do not affect the binding character of the agreement. Unilateral mistake of which the other contracting party has knowledge or has reason to know makes the contract avoidable by the victim of the mistake. The deception situation may be one of negligence, misrepresentation, or fraud. The law ordinarily does not attach any significance to non-disclosure. Contrary to this rule, there is a duty to volunteer information when a confidential relationship exists between the possessor of the knowledge and the other contracting party. When concealment goes beyond mere silence and consists of actively taking steps to hide the truth, the conduct may be classified as fraud. Statement of opinion or value cannot ordinarily be the basis for fraud liability. The voluntary character of a contract may be lacking because the agreement had been obtained by pressure. This may range from undue influence through the array of threats of extreme economic loss, called economic duress, to the threat of physical force that would cause serious personal injury or damage to property, called physical duress. When the voluntary character of an agreement has been destroyed by deception or pressure, the victim may avoid or rescind the contract, or may obtain money damages from the wrongdoer.
Thank you very much. Are there any questions by one of people on this chapter? Any questions? All right. Thank you.